So in this webinar, we will focus on the United Nations human rights system in relation to its relation to conscientious objection to military service. And we will have three very interesting presentations. As I said, we will have three presentations, and we are grateful to all speakers in this webinar. We will hear from Laurel Townhead from Quaker United Nations Office, who is representative for human rights and refugees at QNO. We have Leigh Toomey, chair of the UN Working Group on Arbitrary Detention. And we have Yorgos Keratis, conscientious objector researcher and campaigner from Greece. We are grateful to all our speakers again. Also, thank you, special thanks to Leigh Toomey for being available despite challenging time zones, because I think it is 11 p.m. there now. So thanks again. So we will start with the first presentation now. Laurel Townhead from Quaker United Nations Office, who is representative for human rights and refugees, as mentioned earlier. Laurel's work includes using the UN human rights system to support the right to conscientious objection to military service in law and in practice. She first worked on conscientious objection 17 years ago as research assistant for the Ülke case at the European Court of Human Rights. The floor is Laurel's now. Thank you, Laurel.
Thank you so much, Zemi. I'm just going to take a moment to find my presentation. Okay, thank you all for being here and for joining us for this webinar. So it's my job to give a brief introduction at the beginning, and I'll give a brief overview of what is the UN human rights system and how can it be used in your campaigns for conscientious objection to military service. And I'll skip quickly over some parts which will be covered in more detail by our subsequent presenters. So don't worry, the whole presentation will be sent, but I won't say everything, otherwise we'll be here for too long with me talking. So just to start by saying that I just need to work out how I change. Yeah, within the UN human rights system, there is no treaty that explicitly says that there's a right to conscientious objection to military service, but the system has very clearly recognized that it is a right protected in international law. And we've got three different parts of the human rights system here, each of which we'll touch on in this webinar today. And there's a quote there from each of them, and all of them essentially say that there is a right to conscientious objection to military service because there's a right to freedom of thought, conscience, and religion. And because that's protected, the right to conscientious objection to military service is protected. And so why would we think that the UN human rights system is relevant for campaigning for conscientious objection to military service? Well, partly because it sets these standards. It has this role in creating international law and interpreting international law, but also because it can provide oversight and accountability for the commitments that states have made. So a space to challenge whether governments are actually doing what they've said they will do. And also that it can provide guidance and technical assistance. So it can speak to what governments should be doing to make sure that somebody can safely claim that right as a conscientious objector. And this makes it relevant to both countries that do not have any recognition of conscientious objection to military service, where that can be challenged, the complete lack of recognition, but also it's relevant for countries where there is a recognition of conscientious objection to military service, but in practice there continue to be rights violations. Either the alternative service is punitive or the way in which you get recognized as a conscientious objector is unfair, for example. So what is the UN human rights system when we use this phrase? It's made up of lots of different parts. This is an organogram from the Office of the High Commissioner for Human Rights, which shows that there are many different parts. So I'll just speak to a few of them today. And the idea is really that I give a bit of technical introduction to what it is, and then our two subsequent presentations will give some real practical kind of depth on what some of those things are, and that hopefully we can use the Q&A and the session at the end to find out how we can help support people to engage with the system where they want to. So starting first with the Human Rights Council. This is a political body. It's made up of governments representing their positions and their priorities. It's an intergovernmental body intended to strengthen the promotion and protection of human rights and address situations of human rights violations. It's meeting right now in Geneva in virtual format, as we all are, but it's currently in session. And one way to think about the Human Rights Council is to think about its roles listening, so receiving reports, holding debates and discussions, but also in speaking, so providing a space into which registered NGOs, states can speak about about their position on human rights, but also the council speaks as a group of member states. It passes resolutions. There's a quote, one of the first quotes there about the recognition of the right to conscientious objection is from a Human Rights Council resolution. So that's that state saying, what can we say together as a group of governments on this particular right, on this particular situation at this moment in time. There's some lists of some parts of its work and some entry points, but thinking specifically about conscientious objection, there are some particular things which are of use in your potentially of use in your campaigning. One is that there's a report from the Office of the High Commissioner for Human Rights, which is scheduled to come every 4 years. And that contains information on conscientious objection around the world and recommendations for governments, and any organization could submit information to that. You don't need any kind of special standing. The Council has passed several resolutions on conscientious objection, currently on a 4-year cycle. And these have provided clarity about the law, but they've also provided some additional standards. So, for example, the alternative service must be in line with the reasons for objection. Resolutions can also ask for follow-up activity from the Office of the High Commissioner for Human Rights. So, for example, they can ask for specific reports. There is the debates and dialogues on the reports with special procedures, and we'll speak briefly about the special procedures in a minute. And they're an opportunity for people to raise questions and recommendations in the council. So now we'll speak to the special procedures. That's another part of the UN's human rights system. And Leigh will speak more about this because she is the chair of the working group on arbitrary detention, which is a special procedure of the Human Rights Council. This is a term we use, which doesn't really make very much sense in usual English, but it's a term that's used for the group of independent experts who can advise on themes or on countries. And they're not employed by the UN or by member states. They're independent and they provide technical advice and expertise around specific human rights situations, specific human rights issues. They have a variety of activities, some of which Leigh will touch on, and there are a variety of entry points for NGOs as well, and particularly in relation to your work as campaigning for conscientious objection, it's worth thinking about the country visits that special procedures can do, that you can supply information before they visit. It's possible sometimes to meet with the special procedures. They'll meet with the government, with NGOs, with human rights defenders, and then prepare a report analysing the situation in the country and then making recommendations to the government. Also, special procedures will produce thematic reports, which may be relevant to conscientious objection. And again, you don't need any particular registration or type of NGO in order to be able to submit information to these. And finally, they can receive communications about individual human rights violations. And Leigh will probably speak a little bit more about the specific role that the working group on arbitrary detention has. Moving on to the Universal Periodic Review, which is another part that was in that organogram of the human rights system. The Universal Periodic Review is an intergovernmental process, so government to government, to review the human rights record of every country once every 5 years and to make recommendations. Now, NGOs like us can't make recommendations directly, but we can give information to try and make sure that the things that we care about, the things that are happening for conscientious objectors are taken into account, and ideally that recommendations are made to your governments about better upholding the right to conscientious objection to military service. There's a little diagram here of seeing the UPR as a cycle. So even if your government isn't up for review in the next few months, in the next year, they'll be at some point in this cycle, and there are different ways to engage depending where they are in that cycle. And again, I'm going to skip over some of this quite quickly, but we'll share the slides afterwards so you can read it with more time later. And in terms of what ways in there are for NGOs, for organizations, for conscientious objectors, you can submit written information to the UPR around 8 months in advance of a country being reviewed. And again, you don't need any special status to be able to do that. So you can submit written information, and I4, so Zaire, regularly submits information on conscientious objection to military service. You can also try and engage with the countries who might make recommendations about conscientious objection to another government. So there's a group of countries who have done this in the past and who might be likely to do it again, and you can engage with them in Geneva, in the capitals of those countries, but also in the country that you're in. If there's an embassy, then it's they will sometimes be open to receiving information there. So it doesn't necessarily require travel. It doesn't necessarily require a lot of in-person contact. And suggested recommendations can be shared with them. That's something which we regularly do, and it's something which I4 has done in bringing conscientious objectors to Geneva to meet with diplomats to explain what the situation is in a particular country, to encourage them to make the recommendations. And then the UPR is intended to be a process of consultation and dialogue. And so where it's safe to do so, it can be an opening for dialogue with your government. So that will depend on the safety for you and the safety in your country to do that. But that can be a moment that opens the possibility for dialogue before they report or once they've received the recommendations from other countries. There's a slide in here on the Office of the High Commissioner for Human Rights to look at later. And then the last part of the system I wanted to speak about, and hopefully George will speak a bit more about their experience of this, is the treaty bodies. So this is groups of independent experts who monitor the implementation of a human rights treaty where a country has signed up to it. There are 9 core treaty bodies, that's them listed there. The one that's most relevant for us on work on conscientious objection is the Human Rights Committee, because that oversees the implementation of the International Covenant on Civil and Political Rights, which contains the right to freedom of thought, conscience, and belief. There are different ways to engage with it in terms of when it receives reports from countries, and in terms of its work on interpretive guidance and on cases. So when a state is going to report, you can send in information. And again, that doesn't require you to have a particular registration with the UN to send that kind of information. You can send suggested recommendations, and you can watch as your country is reviewed by the Human Rights Committee to see what is said to them, to see what's recommended. You can also submit cases, individual cases, to treaty bodies if your country has said that they accept that. So there's quite a big limitation on that, but where that's possible, you can submit cases. And again, hopefully George will speak a little bit about the experience in Greece of using this. So when would you consider working with the UN system as part of your campaigning? And I think it depends on where you're at in your campaigns, what you would like to do. But for example, the submissions to reports and reviews, that's all got a timeline of its own. So you can't just turn up and say, I want to submit on the UPR. It depends on what its timeline is. So part of the work is then about looking at where are the moments when your country will be reviewed? Where are the moments when a report in conscientious objection is coming up? Do you already have information you can adapt, or is this something you'd like to invest time and energy in preparing for? And good submissions will contain clear information detailing rights violations, but also relevant laws and policies, as well as what's happening to individuals, and clear recommendations. And it's always worth thinking, do you think it will actually help your campaign if the UN recommends this to your government? In relation to individual cases, it's important to emphasize this is not a quick solution. This is a slow process. It can be very effective in changing laws ultimately, but it's definitely not a quick process. And as I mentioned, the state in question has to have accepted that it will take individual cases. And then the question about whether it's a good approach or not are the same questions as were asked in the litigation, the strategic litigation seminar, webinar that we did previously. And finally, so what has been achieved by previous engagement on conscientious objection in the human rights system? So firstly and crucially, recognition of the right to CO as a right protected in international law, progressive clarification of what international law says about what should actually happen to enable a person to safely claim their right as a conscientious objector. It's had an impact on the decisions of national courts, including constitutional courts, and we heard a bit about that from the case studies of both Colombia and Republic of Korea last time. It has ordered remedy for individual cases. It provides a space where other governments can show their support for the right to conscientious objector, to conscientious objection and for conscientious objectors. And it provides tools for national activists and organizations to use with their governments. So finally, just to say, I think it can be a useful part of a strategy alongside the other pieces that we're touching on in this webinar series. And that's where I'll leave it for now.
As Sami has already said, we are very pleased to have her with us today. I will provide some quick information. She is the chair of the UN Working Group on Arbitrary Detention since August 2015. And she has served also as vice chair on follow-up. She has taught human rights and criminal justice reform at the Queensland University of Technology and for the Royal Wallenberg Institute of Human Rights and Humanitarian Law. She is qualified as a solicitor in England and Wales and as a barrister in Australia. Her experience includes intensive field-based work in developing conflict and post-conflict settings worldwide for UN agencies, NGOs, academic institutions, and development organizations. So thank you very much for being here with us. Thank you.
Thank you very much for that kind introduction. Can you all hear me? Great. Well, as was mentioned, my name is Leigh Toomey. I'm the current chair of the UN Working Group on Arbitrary Detention. I just want to commence by thanking the organisers for putting on this wonderful webinar today and for the invitation to join you all. It's a real privilege, and this is a really important topic, not only for everyone to hear about, but for a chance for me to tell you a little bit about the working group's work on this issue. A few words, first of all, to complement Laurel's presentation about the special procedures. As she mentioned, the UN Working Group is one of those special procedures, and it's composed of 5 members from around the world. Each of the 5 regional groupings, Western Europe, Eastern Europe, Africa, the group of Latin American and Caribbean states, and Asia Pacific are represented on our group. So we have 5 members. We sit in Geneva 3 times a year, usually April, August, and November. At the moment, all of our work is going on virtually, as you can imagine, because of the pandemic. Some of the important functions that we carry out, Laurel adverted to, but let me talk a little bit more in detail. Unlike other special procedures, the working group has a particular function of adopting opinions on cases that are brought before us. We call that our regular procedure. So let's say there's an alleged human rights violation involving detention of someone. It could be the detention of a conscientious objector to military service in a particular country. We have people bringing those cases before us, which we consider when we're in session in Geneva, and we adopt an opinion. Every year we adopt about 80 to 90 opinions. So it's quite a heavy workload, but we find it probably the most effective aspect of our work because it allows us to really engage on specific issues and to set the working group's jurisprudence on particular issues. We also issue what's known as urgent appeals and allegation letters, which is a little bit quicker process. It involves writing in a confidential manner to states with allegations, just to find out in urgent situations what's going on with someone in detention. And we often join with other special procedures mandate holders in doing that. Thirdly, we carry out country visits to states involved. Laurel mentioned those. Those haven't been going on right across the special procedures at the moment because of the pandemic, but will hopefully resume in the second part of this year. And finally, we write deliberations, which are like the general comments of treaty bodies that set out the law on different aspects of our work. You can find all of this information on our website, and I'll give it to Laurel as well to make available to you. So that's a little bit about our work. I thought you might be also interested, which I can address perhaps at the end of this presentation or during the Q&A, on how civil society can engage with the working group as well. So I'll be happy to give you some information on that. In terms of our thinking on conscientious objection to military service, I think it's fair to say that the working group's work has evolved over the years. It's now 30 years this year since the working group was created by the Commission on Human Rights in 1991. And that approach has really changed dramatically from 1991 till 2021. At the beginning, we had a number of cases that came to us from Greece, from Turkey, from other states such as Colombia, where conscientious objection was the problem and may still be a problem. In those cases, the working group tended to look at the issue not in terms of depriving people of their right to have their own conscientious objections, whether based on faith or other reasons of pacifism, but looked at it in a very technical point of view, in terms of when people were being repeatedly detained for their conscientious objection, whether that constituted a violation of double jeopardy. Under international law, you are not allowed to be placed in double jeopardy, being repeatedly punished for the same offence. And that was the approach that the working group took initially. I should tell you, actually, by way of background as well, that the working group looks at detention in a very structured way. We analyse detention issues and whether it's arbitrary, because not all detention under international law is arbitrary. As you know, people do go to jail and are regularly detained, but it's when, firstly, when there's no legal basis for a detention, when someone's detained, for example, without an arrest warrant or stays beyond their sentence, we would say there's no legal basis. Secondly, when someone is detained for exercising their rights, such as their freedom of expression, freedom of religion, freedom of conscientious objection, if they're detained for that reason, we would call it arbitrary. Thirdly, we call arbitrary detention that's based on a situation where fair trial rights were not afforded to the particular person detained. They didn't have a lawyer, they were detained too long, there was undue delay in their matter, all of these kinds of matters that can make a fair trial unfair. Fourthly, we look at immigration detention, which is not directly relevant to conscientious objection. And fifthly, we look at discrimination. So if someone's detained for their religious beliefs, for example, we would find that to be arbitrary. So those are the 5 categories we use. And as I mentioned in the beginning of our jurisprudence, we tended to look at military conscientious objection to military service through a very due process lens and whether people were in effect being punished repeatedly, so much so that it violated their rights to hold their own beliefs. Now, over the years, we came to evolve to a different position where we started to recognise, as did the Human Rights Committee that Laurel mentioned, that there is a right to conscientious objection. It's not specifically mentioned in the International Covenant on Civil and Political Rights, but it's inherent in the right to have a religious belief or conscience, thought and religion. And a lot of cases started to come to us from places like Colombia, Turkey, Israel. And the working group eventually found that there is such a right, but that when you tell a state that you're a conscientious objector, that's a manifestation of your religion or belief under Article 18.3 of the International Covenant on Civil and Political Rights, and can therefore be limited by states if necessary for reasons of national security, health, morals and order, etc. So at that point, around about the early 2000s, 2003 to 2008, our jurisprudence hadn't yet fully evolved to where it is now, but it was changing. Now, in 2018, we had a number of landmark cases, which you may have discussed in your first webinar, come to the working group from South Korea, from Jehovah's Witnesses who had been detained on the basis of their conscientious objection. And in that case, there were 2 actually, which I've given to Laurel and she can share with you later, in which the working group finally found that conscientious objection is not a manifestation of religion or belief. Rather, it's an absolutely protected right under Article 18.1 of the Covenant, which cannot be restricted by states in any way. So states can't argue that there were any reasons of national security, health, morals, etc., that would limit the right to conscientious objection. And that's the current position of the working group. It was most recently outlined in one of our annual reports in 2019. And so we have had subsequent cases to those, which we treat as being arbitrary. If someone's detained on the basis of being a conscientious objector, we consider that to be arbitrary, what we call per se, that is in obvious violation of Article 18 of the International Covenant on Civil and Political Rights. Now, this might all sound a little bit technical, but it's actually an important move to recognizing from a more procedural point of view to now recognizing that the right not to be involved in the potential taking of life is so important that it needs to be subject to absolute protection. And the working group now recognizes that. So that's just a very short history of the evolution of our thinking. I can certainly go into it more if anybody would like to know. But if you're conducting advocacy on conscientious objection and want to engage with the working group on arbitrary detention, I've got a couple of ideas on how you could do so. First of all, the group maintains an open door policy. So anybody, be they a state, an NGO, a family affected by detention can come and see us when we're in session in Geneva at any time, or at the moment, set up a virtual meeting with at least one of the members to discuss concerns on a confidential basis. We also hold an annual civil society meeting in Geneva in our August session, at which we invite a lot of stakeholders to come along. I think, Laurel, we've seen you there on a few occasions in the past, and that's an important opportunity to come and tell the working group about contemporary issues that are going on conscientious objection and other human rights violations concerning detention on the ground. Laurel mentioned country visits, which are also very important. I would say, in addition to meeting with the working group during country visits, there's a step before it that's very important for your advocacy work, and that is controversial mandates like the working group. States don't always like to have arbitrary detentions pointed out, so it can be difficult from time to time to secure invitations, and there are a lot of special procedures, thematic and country seeking country visits. So we often speak to our NGO partners and others on the ground who do important advocacy for us in actually lobbying for the state to extend an invitation to the working group to come to a country. We can't come to a country without an invitation from the state. So it's a really important means of advocacy for civil society on the ground to lobby for that potential. We tend to focus, but not exclusively, on states that have offered what's called a standing invitation to the special procedures. About probably 80 or so states have offered what's called a standing invitation to special procedures, and that means that, in theory at least, we have the right to seek an invitation at any time to come and undertake a country visit. It's not always honoured in practice because states have elections coming up, they have other special procedures visiting, but it can be useful to approach states that have that standing invitation, and you can find out whether that's the case for your country on the OHCHR website if you Google OHCHR and standing invitation. So that's a really important way of us to find out what's going on the ground in terms of COs. Other ways, in September, the working group presents its annual report to the Human Rights Council in Geneva. Last year I presented it and it was done virtually because of the pandemic, but usually the chairperson goes along in person and presents it in Geneva, and we hope that will be the case this year. In any event, whether it's in person or whether it's virtual, civil society has the right to speak very briefly, unfortunately, at those presentations and to really give their views on different human rights issues, including conscientious objections. So that's a very important opportunity. And of course, as I mentioned, if you have any particular situations of alleged violations that you know about, you can always contact the working group through our secretariat in Geneva about issuing a communication, an urgent appeal if someone's in a desperately difficult and grave health or psychological situation, or taking a longer process to actually issue an opinion on the topic. That's probably enough from me at the moment, but if anybody has any questions, I'd be happy to answer them either now or at the end of the session. Thank you.
I'm pleased now to present Georgios Keratis. He is a conscientious objector, a researcher, and a campaigner from Greece. He has collaborated with various organizations, including Amnesty International, European Bureau for Conscientious Objection, I4, and WRI, in advocacy efforts for the right of conscientious objectors within the UN bodies and procedures. Thank you very much, George, for being here with us. The floor is yours.
Thank you very much, Zaira. I don't know if you can hear me well. Can you hear me? Okay. Thank you very much, the organizers, and perhaps Natalia can help me a little bit with a PowerPoint. So let's start with the first picture. Conscientious objectors from Greece and the organizations defending their rights have been engaged for years in advocacy efforts within the UN human rights system. This presentation will focus on recent efforts since 2015 in the context of the following bodies and procedures: the Human Rights Committee, the Universal Periodic Review, the UPR, the Special Rapporteur on Freedom of Religion or Belief, the Office of the High Commissioner for Human Rights, and the Working Group on Arbitrary Detention. As for the Human Rights Committee, it's the next picture. As for the Human Rights Committee, we used two procedures. The first one is about individual complaints or communications. There is a case pending at the Human Rights Committee. We have not publicized it for reasons of strategy, so I will not comment on it. The only thing I would like to comment, especially for our friends in Europe, is that regardless of the result in this specific case, and despite some successful cases of Greek conscientious objectors at the European Court of Human Rights, I do believe that the Human Rights Committee is a much better body to submit such individual complaints. The Human Rights Committee has much more experience about conscientious objection issues. It has better standards than the European Court of Human Rights, so I believe it's a preferable choice for COs. Now, the second procedure is that of the periodic report. Let's see the next picture. This procedure has mainly two stages. The first stage is the one prior to the list of issues. Here, our goal was first of all to convince the committee that the human rights issues concerning conscientious objectors are important enough to be included in the list of issues. And the second goal was to propose adequate questions to the committee to be posed to the state party, in this case to Greece, in order for the real picture of the situation to be revealed. Now, the second stage is the stage before the concluding observations of the committee. And here our goal was to achieve adequate recommendations by the committee. The methods we used, the tools we used were written submissions. There was also a formal hearing during the session of the committee before the concluding observations. And there were also informal briefings with members of the committee. The latter, I believe it's very important because in these informal briefings, we have more time to explain the situation and the human rights violations that occur. Now, we have achieved a rather extensive and comprehensive recommendation by the Human Rights Committee the last time in 2015. I will not read it for reasons of time, just to point out that there are several issues: the issue of the punitive alternative service, the issue of the examination procedures, and the issue of the repeated punishment in violation of ne bis in idem principle. Now, the next procedure we have used is the Universal Periodic Review in the context of the Human Rights Council. Here, the goal is again to convince other states, convince the delegations of other states that the human rights issues concerning the consensus objectors are important enough to be included in the recommendations to the state party under review, in this case to Greece. And also we have to propose some adequate recommendations to the other states in order for them to make these recommendations to Greece. Again, the tools we have used were written submissions. We also made an application through EPCO to participate in a pre-session organized by an NGO called UPR Info. Unfortunately, we were not nominated as speakers in this event. However, we were present at the event, at the pre-session, and we did some informal lobbying with members of delegations of other states who had come to listen about Greece. And apart from this, we had some somehow more formal meeting with a member of one delegation. Now, what we have achieved? We have achieved two rather good recommendations. Again, I will not read them, you can see them. Especially the one of Slovenia is very important because it's asking for an alternative service of equal length, which apparently follows the standard of the European Parliament. And of course, these recommendations were not accepted by Greece, but later there were some improvements in the legislation and in practice, as we will see afterwards. So we also approached the Special Rapporteur on Freedom of Religion or Belief. We wrote letters, both individual and by organizations. We had meetings with members of his staff and follow-up communications by email. And we achieved in recent years 2 official communications by the Special Rapporteur towards the Greek authorities. The first one included also an individual case of a consensus objector whose application has been rejected, and perhaps this communication has contributed to his recognition finally after many years, more than 10 years, 13 years, and I believe he is present at this meeting. Maybe afterwards, if he wants, he would like to speak. And the second communication came, to be honest, came somehow late after the amendments in the legislation, but still it was important, and it is important because despite some improvements achieved in the legislation, the Special Rapporteur asked for more improvements. Furthermore, we have approached the Office of the High Commissioner for Human Rights, and we did 2 things. The first one was having an informal meeting with a member of the office who gave us a very useful guidance through the UN human rights system and the contacts, persons to meet from the different procedures and bodies. And the second thing is that we are regularly doing is include examples from Greece in the submissions of various organizations for the relevant reports about consensus objectors, both for the report which comes out every 4 years and also for the special thematic reports about objectors. And finally, many examples from Greece are cited in these reports. Finally, we have also approached the working group on arbitrary detention, both through informal meetings with members of the staff working for the group, and also there has been a written submission by Amnesty International specifically for consensus objectors in the context of the visit of the group in Greece. To be honest, till today, I'm not aware of something very specific, something concrete issued by the working group about consensus objectors in Greece in recent years. Perhaps Leigh can correct me if I'm wrong. But hopefully in the future, we might have something also from the working group on arbitrary detention. I believe there are issues. We still have arrests and brief detentions. We have the issue of repeated punishment, the issue of fair trials, because we have trials in military courts. So I believe there are issues to look. Now, all these advocacy efforts at the UN level, together with other efforts, of course, in Greece, I believe have contributed in some results. I will mention very briefly some of them, just to show that such efforts are effective, at least to a certain extent. In practice, at least for a certain period of time, it seemed that more consensus objectors were recognized as such, including certain cases of objectors who had been previously rejected. Their applications had been rejected and afterwards they were recognized. As for the legislation, we achieved an amendment of the provision about the length of alternative service. Subsequently, there has been a ministerial decision which reduced the length of alternative service. Unfortunately, this was later repealed by the next government. We managed also to have repealed a negative provision which was given to the Minister of National Defense the opportunity to suspend all provisions about consensus objectors in wartime. I believe this is important. We managed also to reduce the number of military members in the examination committee from 2 to 1 and increase the civilian members from 3 to 4. Of course, this is not enough. This is not sufficient. There should be no military members at all in the committee that makes the examination. We also have improvements in the legislation about the consensus objectors of greater age, and also we managed to have extended certain benefits or certain provisions that were already given or already valid for the conscripts serving military service. We managed to extend them also for consensus objectors serving alternative service. Before ending, I would like to recommend some tips for fellow consensus objectors and friends from other countries. First of all, have patience. The procedures at the UN are long, and even after achieving something at UN level, some recommendation, for example, it takes time to have concrete results on the ground. Next thing is be insistent. The first efforts might not be successful, but keep trying. And I would say keep disturbing the UN officials. And the other thing is try to collaborate with organizations that have staff at UN, for example, in Geneva. I believe it's very important. And if possible, to visit the UN premises and have meetings with people from UN. It's also useful to combine, on the one hand, written submissions, and on the other hand, if there is possibility to have some formal hearing, but also to have informal meetings where usually we have more time than the formal ones. We have more time to explain the situation. And also it's important in some cases to follow up with communication by email afterwards with staff, with people from the UN procedures. And the last thing is that it's very important, in my opinion, what we are doing afterwards with the recommendations, the follow-up work. I believe it's very important to inform journalists, inform the media, try to raise attention about such UN recommendations, to inform members of the Parliament and of the European Parliament, to inform lawyers so they can use such recommendations in trials in domestic courts and see if they can have some effect. Of course, to inform international CO organizations and other NGOs which are supportive to our cause, for our rights. And I believe also it's very important to inform other UN bodies and procedures about the recommendations. So we have a recommendation from one body. It's very important to inform other bodies, other procedures, other mandates about such recommendations. And of course, we need to repeat at every opportunity such recommendations to the authorities. Before closing, I would like to thank all the people and the organizations, including Amnesty International, EPCO, IFOR, CUNO, War Resisters International, and others, and institutions, including the Greek National Commission for Human Rights, which have supported advocacy efforts within the UN human rights system for the rights of conscientious objectors in Greece. And if you permit me, I would like to personally thank certain people like Derek and Rachel Brett, Friedhelm Schneider, Zaira Zafarana, Laurel Townhead, Semih Sapmaz, and many others. Forgive me, I cannot mention everybody. Thank you very much for contributing in these efforts for supporting the human rights of Greek conscientious objectors. Thank you.
Thank you very much, George. Thank you for this very informative presentation and the useful tips. At WRI, together with our partner organizations, which you have mentioned in your presentation, we have been following the situation in Greece for many years now, and it's inspiring to hear how you have been using the UN system to pressure the Greek government on the issue and the improvements you have achieved in Greece. But also you mentioned, of course, the ongoing problems, including the involvement of the military in the application process for COs, the punitive nature of the alternative system, ongoing repeated punishment for COs. And yeah, overall, the ongoing reluctance of the Greek government to take action on this, I guess.